Let me try.
The judgment just delivered allowed the case of the plaintiffs, which is the Rivers State government, as filed by the Attorney General of Rivers State, allowed it in part. And the judgment has not been given to us, but we're being assured that in a few days, the comprehensive judgment will get to us and we'll see the detail. We will not want to preempt the content of the judgment until we have received the certified true copy of the judgment from the Supreme Court. But however, it is heartwarming to say that the steps taken by the two state governments and the federal government are steps that should encourage the other entities, state governments, should be encouraged to follow such steps. And that is approaching their dispute with civility, rather than having disputes between states, boundaries and the rest of them, allowing people to resort into anarchy. The most civilized way of doing things is what these two state governments and the federal government have demonstrated. And we thank the intervention of the Supreme Court, which has brought an end to that dispute. Thank you very much.
No, but from the simple explanation of the court, reliefs 1, 3, 4, 5, and 6 were granted. Why 1, 3,
why 2, 7,
2, 7 were refused?
Yes, we will wait to see, to get the certified true copy of the judgment before we make any comment on it.
Well, the little I had is that this claim succeeds in part and refused in part. Unfortunately, the pronouncement was not audible enough for us to know which reliefs have been refused or this one granted. But all we know is that when there is commencement of a proceeding, it terminates in judgment. The court has said that the judgment will be released to us, then we'll know the way granted. Whichever way the details are, we'll be able to comment on the details. At the moment, we know that the river that was the plaintiff succeeded in part and paid in part. The counter-claim which we made was rejected by the court. When we have the details, we'll be able to comment on it.
All right, thank you very much.
Just for the benefit of those who don't know, what were your counter-claims?
We counter-claimed asking for listed oil wells based on over a century relationship between the oil producing communities and the oil producing companies. We have agreements, receipts, MOU, permits that were granted by these oil communities for over 100 years. And we rely on the decision of this court to the fact that if you have evidence of possession or occupation of a portion of land, that court can make a declaration of it. That was the basis of it.
Do you have your reaction to the judgment just delivered?
Well, you should know my position in this matter. I'm for the Attorney General of the Federation and the Minister for Justice. Our position is a position of a neutral in this matter. We basically urge the Supreme Court in our defense to the claim filed by the government of Rivers State that the Supreme Court should allow National Boundary Commission to put all instruments together and assist the two states to draw the appropriate boundary and decide on the basis of science where the oil wells should be. That was the position we canvassed, and we listened to the judgment, which was delivered in summary we were told that the reliefs are granted in parts and then refused in parts. To be able to give you the details of what was granted and what was refused, we must have a copy of the judgment. And I could see that the judges were having drafts of the judgment. And hopefully before the close of business today, or latest on Monday, by the grace of God, we should be able to have the detailed judgment, and we'll be able to give you further information if they will be necessary for you.
The Supreme Court has spoken. The appeal filed by the appellant has been dismissed, but the full reasons for the judgment will be given in the few days ahead. So what it means right now is that, well, the judgment of the Court of Appeal has been affirmed by the Supreme Court.
So the implication, just let us spell it out. Let's understand.
The implication of it is that the action filed by the appellants at the trial court, the orders made by the trial court have been dismissed, just like the Court of Appeal did. Those actions have been dismissed. The Court of Appeal said, even in its judgment, that the trial court had no jurisdiction to even have entertained that matter in the first place, so which the Court of Appeal affirmed. So I believe when we see the full, content of the judgment, it will go along the same line, since that the judgment of the Court of Appeal has been affirmed.
All right, thank you, sir.
Thank you very much.
Thanks for checking out SYMFONI on YouTube. Please be sure to subscribe and like our videos for updates.